Getting a letter from the Bureau of the Fiscal Service is a terrifying moment. The government can take your wages without a court order using administrative wage garnishment. Ignoring this notice leads to an automatic judgment, taking away your chance to respond. But federal law gives you specific rights and defenses they don't always advertise. We will now break down your rights, the limits, and the exact steps to fight back. By law, you must get a written notice at least 30 days before garnishment. This is the starting gun for your defense. This document must clearly state the debt's nature and amount, and it must explain your right to a hearing. You can pay in full, negotiate, or dispute. But your most powerful right is a hearing, and when you ask is critical. More on that in a moment. You must request a hearing within 15 business days of the notice date. It is a very tight window that many people miss. Miss this deadline, and they can start the garnishment while your request is considered. Meeting it forces them to pause. So, you have a 30-day notice with a critical 15-day action window. Now, let's see how much money they can actually take. Garnishment is based on your disposable pay, what's left after taxes, health insurance, and other required deductions. Administrative wage garnishment allows them to take up to 15% of that disposable pay. It's a fixed, predictable percentage. However, you are legally entitled to keep an amount equal to 30 times the federal minimum wage each pay period. If you have other garnishments, the total from all sources cannot exceed 25% of your disposable pay. The AWG must shrink to fit. Remember that 15-day deadline? Requesting a hearing in that window stops the clock. It pauses the 15% deduction, giving you time. Now that you know the financial rules, let's look at specific circumstances that can stop a garnishment entirely. They cannot garnish your wages if you've been at your current job for less than 12 months and were involuntarily fired from your last one. Your employer cannot fire you, refuse to hire you, or discipline you just because of this garnishment order. Your livelihood is protected. If your situation changes, a medical emergency, divorce, or disability, you can request a review for financial hardship. Certain income is completely off limits. This includes Social Security, SSI, and disability benefits. They cannot be touched. Those were built-in protections. But you can also go on the offensive. Let's cover 3 ways to actively challenge the garnishment. First, you can file a formal objection. Grounds include improper notification, mistaken identity, or calculation errors. Second, you can demand debt validation. This forces the agency to produce documents proving the debt is yours and the amount is accurate. Third, negotiate a payment plan. Agencies often prefer a voluntary, consistent payment over the process of garnishment. You've learned your rights, the limits, and how to challenge the debt. But what if your financial situation is truly overwhelming? Is there a legal tool that can stop wage garnishment in its tracks, immediately? Yes, but it's a significant step. Let's connect 2 ideas. That 15-day hearing deadline gives you the breathing room to prepare your active defense. Time is your resource. Now, connect the math with your life. The 15% limit and minimum wage floor are the legal basis for your financial hardship claim. The ultimate tool to stop garnishment immediately is filing for bankruptcy. This is the emergency brake we mentioned. The moment you file, a legal protection called the automatic stay goes into effect, forcing all collection activities to stop. Let's bring it all together. You have initial rights, financial protections, and active strategies. Knowledge of this structure is your power. As we said at the start, the worst thing you can do is nothing. Ignoring the notice forfeits all the rights we've discussed. These laws are complex. A qualified attorney can assess your specific situation and recommend the best course of action for you. Don't be intimidated. Take out your notice, mark the 15-day deadline, and start evaluating your options. You have the knowledge. Now act.